Okay, it's time to talk a little bit about copyright issues on the internet. I mentioned to you previously that when we deal with copyright, there are a lot of problems and issues that arise because of the nature of digital technologies. So I want you to contrast digital environments with physical media and some of the old school notions of copyright. After all, this was the world in which copyright policies were originally designed, when we conducted ourselves with paper and canvases and tapes. For instance, think about traditional books that are printed with paper. Now, consider how somebody might engage in copyright infringement of a particular title. Of course, you know how difficult it is just to copy 25 or 50 pages of a book on a standard machine. It would be way too time-consuming and expensive to copy an entire book, and the end result would cost more to make than the original's price. Thus, to make an operation really pay off, somebody has to have some kind of massive photocopy machine with binding equipment and an efficient warehousing and distribution network. This means that with paper, the copying typically will be centralized at these major hubs where the infringement originates. It also means that the copyright owner can take aim at the centralized hubs, because if their operations are shut down, then the supply of infringing book copies will dry up. So, in this world, copyright owners can sue these centralized businesses for infringement, and will likely win due to the unlawful reproductions and distributions. They will be awarded damages for infringement and usually can collect because these are commercial enterprises that are making money. The court also will probably issue an injunction preventing further copies or sales. So it all kind of works. It's pretty easy to find the big infringers, get compensated for what they've done, and shut them down, which ultimately keeps unlawful copies out of the hands of consumers. Now enter the digital world, the one you live in. You no longer need a huge printing press to engage in infringement. You merely have to push a couple of keys on your desktop and bing, you made your own copy. And bang, you can send it to your friends who, boom, can do the same things. So in this environment, the infringements are decentralized all over the place because they basically take place in our homes. This leads to several new problems for copyright owners. First, there are no longer major infringement centers that are easy to track down. Now, people are individually infringing on their personal computers, iPads, and phones, making them difficult to locate. Then, of course, if you do find them, they turn out to be kids in their bedrooms who have no money. So what's the point of suing them, since the lawsuit will cost you money and they can't pay you back? Also, what good is an injunction since it only stops one person and has no effect on what anybody else is doing? Thus, there's an enormous problem with enforcement when works are digitized. What can copyright owners do to overcome these hurdles? One possibility might be to go after the platform that facilitates the individual infringements and claim that they bear legal responsibility for what their customers are doing. For instance, you might argue in court that none of these infringements would have happened if Verizon or AOL or Facebook or Amazon or whoever prevented their customers from using their services to violate copyrights in the first place. They are like the means to a bad end and should bear responsibility for what went wrong. And if you prevail with this argument, then they have the money to pay, and an injunction would stop a huge swath of people that use their services in illegal ways. It would also give the companies incentives to put in controls that might prevent further infringements. For instance, if you could make Instagram pay whenever customers illegally post screenshots, you can be sure that the company would find technical ways to prevent the activity in the future. Otherwise, it would be on the hook to compensate all of the aggrieved photographers. Thus, think of the digital platform as a hub of a wheel, and the customers who use it are the spokes. If the hub is responsible for what customers do wrong, then the operator is easy to find, has the means to pay, and can pull the plug on its customers. In effect, you are finding a centralized actor to attack, just like the printing press in the world of paper books. And these concepts do not solely apply to internet-related services. Think of DVRs or other recording devices that customers often use to infringe copyrights. If you could go after the manufacturers of these machines and win, then a lot of your problems would be solved. The same is true of software products or other technologies that customers might wrongfully use. You cut off the knees of the hub and you disable the conduct by the spokes. So this notion of legal responsibility is really important, and we're going to spend a bunch of time on it. But I want to first mention just a few other ways to address the problems with digital infringements. Think about these as the arrows in your quiver that you might use to deter the infringements. One thing you might do is to employ technologies that prevent people from doing certain things with your copyrighted work without your approval. For instance, you might use encryption techniques to shield your work and only allow decryption for certain purposes, such as for viewing, but not copying or distribution. Now, the one thing about security in any environment is that people who want your stuff will take steps to break your security. This is no less true in the digital world as it is in the physical space. Encryption, for example, relies on encryption keys to unlock the scrambled content. And would-be copyright pirates will constantly attempt to figure out what those keys are. I'm not sure whether we'll spend much time on this topic, but there's a special law called the Digital Millennium Copyright Act, and a portion of it makes it illegal to break the digital locks. Anyway, take it from me now that this can be very controversial. And if we don't get to it, I can point you to helpful resources. Another technique you can use is to scare potential infringers about what will happen to them if they are caught. In fact, scare them so much that they won't take the chance, even if it's very unlikely that you will discover what they have done. To this end, copyright industries put pressure on lawmakers to increase the penalties for infringement. It's like, if you are caught, then you will go to prison for the rest of your life. Of course, that's an exaggeration, but you get what I mean. The result is so terrible in terms of the money and perhaps jail time that it's just not worth it. Sure, it will be hard to learn what you have done, but if we do, oh baby, will you be sorry. And then the last technique is kind of tied to this. The copyright owner lets you know how awful it will be if you are caught, and then makes it more attractive for you to get the stuff you want legally. For instance, the recording companies now allow you to legally stream almost anything you want for a few dollars a month. Sure, you can steal it for free, but is it really worth taking the chance of being caught when the legal option is so cheap and easy? This is just one way that the industry has become more innovative by developing new business models that deter the incentive to steal their copyrighted works. Okay, I want to return to the notion of finding a central player responsible for the illegal actions of its customers or others. In copyrights, this is typically holding the platform provider, product manufacturer, or software distributor liable for the infringements by the users. And so I posed those very silly examples with the gun shop and the individual shooting elephant seals to draw out from you some of your internal feelings about when it might be fair to pin some responsibility on the gun shop for the injured or dead seal. And I think I heard that the following kinds of things might matter in reaching a decision. One criterion that came through regarded the purpose of the seller, whether it encouraged the illegal actions or intended to help the customer break the law. So you all indicated that if the seller suggested that shooting elephant seals is a good idea and offered a silencer so that the customer might get away with it, then it would be fair and reasonable to hold the seller accountable if the customer followed through and shot the animal. You also told me that if the gun could only be used to shoot elephant seals, then the seller's purpose is pretty clear. The next two items often go hand in hand. If the seller has no idea that the customer might break the law, it's hard to see how they should bear responsibility for the unexpected act. However, if they know that the customer intends to engage in an illegal act and they facilitate its outcome by providing the product or service, then that's a whole different story. We often couple knowledge with control when appraising fault. That is, I know that the user is going to do something bad while I still had some opportunity to stop him. For instance, prior to contemplating the transaction, you might refuse to sell the product if you know that the customer will engage in wrongdoing. But if you learn about it after the sale, then there really is nothing you can do about it. You all pretty much evaluated the sale of the gun in this fashion. Often, with services, such as on the internet, the provider has a continuing relationship with the customer, and so can prevent user access at any time. Under these circumstances, the provider might learn that a customer is using the system illegally, but ignore the information and let the wrongdoing continue. Think of it as, I know what they're doing is wrong, I can stop it, but I'll continue to facilitate their illegality by letting it slide. To use an old phrase, bad dog. The last item to consider is whether the seller or service provider actually profits from the illegal actions. For example, if you set up a transaction where the customer pays you a bonus for each illegal action, then your business has a direct stake in the outcome. Honestly, under these circumstances, it would be hard to argue that you didn't intend for the customers to behave illegally. In a very real sense, your business plan is grounded on illegal conduct, and so you should bear responsibility. These principles are actually all you need to know to understand the outcomes of all of the cases we're about to review. For the remainder of this video, I want to consider two foundational court decisions that set the stage for the file sharing debates, among other issues, which we will look at afterwards. Okay. So first on this agenda is the Supreme Court case, Universal City Studios versus Sony, which involved Sony's sale of the first successful VCR, called the Betamax. It's possible that you've never seen one of these old machines, but you could put in these somewhat large tape cartridges, and the machine could copy the content from a selected TV channel. Sony introduced the Betamax in Japan first, I think in 1975, and soon thereafter introduced it into the United States. And very quickly thereafter, in 1976, Universal and Disney, two major movie studios, sued Sony for copyright infringement. All right, so understand that Sony is not using the machines to copy the studio's copyrighted program. It doesn't put in the tapes or push the record button. Rather, it simply sells the machine and then the customers make copies of TV programs. And the copyrights for many of these programs are owned by Universal and Disney. Thus, the studios argue that Sony is responsible for the fact that its customers use the machine to unlawfully copy their copyrighted content without permission. All right, now, if the customers are indeed violating Universal and Disney's copyrights, then the studios could theoretically sue each of them for copyright infringement. But they would have to track them down, possibly get search warrants, and then gather the tapes proving the infringement. Frankly, I don't know how the customers would be caught, but obviously it would be a monumental, actually probably impossible task. For this reason, the studio sued Sony, claiming it bore responsibility by providing the means for its customers to infringe. And see how effective a victory here would be, because Sony clearly has the financial means to compensate the studios for their losses. And more importantly, the court might issue an injunction prohibiting further sale of the Betamax. So here we go. The studios are taking aim at the hub, which is Sony. And by so doing, they hope to cut off infringements at the spokes, which are Sony's customers. Before this case gets to the Supreme Court, the lower district court ruled that Sony was not liable, but the Court of Appeals reversed. It basically concluded that almost everything one could possibly do with a Betamax would infringe copyrights, and that Sony therefore bore responsibility. The court, in effect, perceived the Betamax as a gun that could only shoot elephant seals. Sony appealed this decision to the Supreme Court, which issued its landmark ruling in 1984. The starting point of its decision is to note that the Copyright Act actually says nothing about when or if a company can be held legally responsible for copyright infringements carried out by others, such as customers. The court therefore looked to the patent system for guidance, relying on the historic kinship between intellectual property protection systems. And the patent statute actually includes a concept called contributory infringement. What is contributory infringement? Under the patent law, if I sell a product that can only or primarily be used for patent infringement, then I become liable for patent infringement as a contributory infringer. So the patent laws directly adopt one of the principles we raised with the elephant gun and the fairness analysis. If the component or process can only be used in a way that infringes a patent, then the seller must want its customers to infringe. On the other hand, if the product could possibly be used in a meaningful number of non-infringing ways, then the seller would not be legally liable. In effect, it would then be like a regular gun. And you told me you would not hold the seller liable just because the buyer used it to shoot the seal. Similarly, the seller of a component that has lawful uses might always be able to argue that he sold it to help customers engage in those lawful ends. Of course, if the seller did other things to encourage the illegal use, then we might see things in another light, but that was not a central consideration in this case. The Supreme Court then ran with this analysis. It determined that if the Betamax were capable of being used in substantial non-infringing ways, then Sony would not be held liable because some people might choose to use it to violate copyrights, just like the manufacturer or seller of a regular gun. And once Sony sells the machine, it loses control over how people use it. We're going to need to contrast that fact next when we look at the Netcom case, which involves an internet service provider. Okay, so this case is going to come down to whether there are substantial non-infringing uses of the VCR's recording function. The appeals court thought that there weren't, and so found Sony liable. In its view, almost everyone who uses the Betamax makes a recording of a copyrighted work, and there are few legally acceptable justifications for those reproductions. Now, if some of the copies might be considered a fair use, things might be different. But the appeals court believed that almost no uses of a VCR could meet the fair use criteria. In its view, fair use must be for purposes such as education, news reporting, criticism, or research. And copying TV programs for entertainment just doesn't cut it. Also, if a lot of copyright owners gave their blessings to the copies, that also might be sufficient. But there just wasn't much evidence of that. Sure, there's Mr. Rogers and maybe a few others, but there would need to be more. Thus, in the end, the appeals court believed that Sony was essentially facilitating an enterprise that was primarily involved with violating copyrights, and so concluded it was appropriate to hold it liable as a contributory infringer. The Supreme Court, though, saw things differently when it came to the application of fair use, at least with respect to one significant use of the VCR. And so I want to tell you up front that this case was important in how it addressed the legality of an innovative technology. But it also was historic because it articulated a more flexible approach to fair use, a trend that then continued with Two Live Crew and other cases. Perhaps the most significant part of the Supreme Court's ruling regarding fair use was how it evaluated the preamble, which states that fair use is for purposes such as research and commentary. According to the court, the "such as" part is only meant to provide some examples of fair use applications, but there could be others, and they may include entertainment under the right circumstances. And what might be the right circumstances? Well, we're going to have to evaluate the specified 4 factors to reach that decision. But before doing so, we need to think about how customers actually use their Betamax video recorders. Some copy and save TV programs in a library so they can watch them over and over again when they want. I have a lot of friends, for instance, that did this with old Twilight Zone episodes. Other people, though, copy programs when they are aired at inconvenient times or when they aren't going to be home so that they can watch them later at a more suitable time. For instance, I often used to tape Saturday Night Live because I was out when it was aired, and then I would watch it with breakfast the next morning. The court called this behavior time shifting because I'm copying to watch the program once at a different time. Someone engaged in time shifting would typically tape over previously recorded and watched programs, and so they wouldn't need all that many tapes for their needs. Anyway, a lot of people use the Betamax for time shifting, and it thus could be considered a substantial use of the machine. Therefore, if time shifting is a fair use, then Sony should not be responsible for the fact that some people use the Betamax in ways that might infringe copyrights. Okay, so now let's apply the 4 factors specifically to time shifting. For if that is a fair use, then Sony is not liable for contributory infringement. The first criteria considers the purpose of time shifting and whether it is commercial or not. As to the purpose, well, entertainment is not within one of the core stated purposes for fair use. So it's hard to say that it's a plus factor. Indeed, it's probably a negative. However, the customers who time shift are not doing so for commercial reasons, which points the other way. So let's say that the purpose factor comes out just slightly negative. Next, the court looked at the nature of the work and the amount that was taken. Ordinarily one might say that these are creative works and the customer copies the whole episodes. So this should weigh heavily against fair use. But the Supreme Court evaluated the situation differently. It said, hey, these programs are shown over TV, and the public is invited to view them in their entirety for free. Thus, it's not all that terrible when people copy something that they can already see so that they can view it once later. Perhaps a little razzle-dazzle, but the court effectively said that these factors don't really matter all that much in these circumstances. Finally, it got to the factor which drove its final decision, which is the effect that time shifting has on the market value of the studio's copyrighted works. Basically, the court's approach was, show us how time shifting costs the studios money, and then we may not consider it to be a fair use. But if you can't demonstrate any meaningful loss, then we'll conclude that the practice is fair. In other words, the studios had the burden of demonstrating how they might lose revenue. So the studios came up with lots of reasons that the Betamax might hurt them financially. Things like it will affect Nielsen ratings because people are copying and watching at different times. Or their advertising strategies are diminished because the target audience may watch the program on a different day and time, thus putting them in a different demographic. Also, the studios argued that time shifting could reduce the number of people who might otherwise watch a movie at the theater. Well, the court didn't believe there was sufficient proof that the studios would suffer losses for any of these reasons, and so it concluded that the market effect was negligible, which tipped the entire balance toward fair use. And since time shifting is a fair use, that means it is a lawful use of the machine. And since customers do a substantial amount of time shifting, this means that Sony cannot be liable for contributory infringement just because some customers use the Betamax in ways that are not legally defensible. So let's be clear. The Supreme Court did not say that anything one might do with a VCR or a DVR is a fair use and thus legal. It only ruled on time shifting. But maybe we'll evaluate in class whether it is okay to save that library of Twilight Zones, or the 3 seasons of the original Star Trek. And it's probably time to think about the modern twist on time shifting, which is called space shifting. Space shifting takes place when you download a copyrighted file to one device. Let's say a music file to your computer, and then you copy it to another device, such as a smartphone, iPad, or to the cloud, so that you can listen to it in other locations. Or, next, as I listed on the slide, what if you copy a television program because you then can skip or fast forward through the commercials? Is that okay? For now, let's consider this food for thought. The next court decision I want to review here is Religious Technology Center versus Netcom, which was the first important case to evaluate contributory infringement in light of the internet. Religious Technology Center is the licensing organization for the Church of Scientology. So you probably know that Scientology tends to be very secretive about some of the teachings of its founder, L. Ron Hubbard. A disgruntled former minister of the church participated on a bulletin board where individuals discussed and criticized Scientology, and he posted copyrighted materials owned by the church on that forum. This bulletin board was hosted by Netcom, meaning that the information was posted and stored on its servers. In response, Religious Technology Center, I'm going to call it RTC, sued the former minister essentially for displaying and distributing Scientology's copyrighted materials without its permission. The important aspect of the case, though, is not about the minister's culpability. And let's just assume for now that what he did violated the copyrights. Rather, what caught everybody's attention was that RTC also sued Netcom, claiming the internet service provider was liable for copyright infringement under these circumstances. RTC goes after Netcom and claims it is liable based on three different approaches: direct infringement, contributory infringement, and something I haven't yet mentioned, vicarious infringement. Let's look first at the argument that Netcom directly infringed the copyrights. The notion here is that the copyright statute makes it illegal to do things like reproduce, display, and distribute copyrighted works. It doesn't qualify the language with terms like knowingly or purposely. Thus, RTC claims that Netcom is liable because the copyrighted materials were reproduced on its servers, and they were distributed by Netcom servers to other internet servers and ultimately to bulletin board participants. Whether Netcom specifically knew what was going on is not relevant. It's enough that the actions took place without permission. According to this view, copyright is pretty much a strict liability statute. That is, you do it, you lose. The judge was not willing to buy this argument in view of the internet's architecture because he believed that it would put an impossible burden on the firms that make it operate. In this regard, he noted that the internet works by mechanically shipping information in packets, often through numerous separate servers, prior to reaching a destination. If there were strict liability, then all of these businesses would be liable for copyright infringement anytime a copyrighted work was distributed over the internet, even though the delivery was transmitted without any human involvement. Of course, this would give enormous incentives for all of these companies to scrutinize the legality of everything passing through their servers, and thus would guard the rights of copyright holders. But at the end of the day, the judge thought those possible benefits did not warrant the virtually impossible burdens that would arise. The judge believed that legal responsibility on the internet is better analogized to photocopy machines that are available for public use, such as the ones you may have once used in a library. Often when you use those machines, you simply copy a couple pages from a book, which likely can be justified as a fair use. But there may be times when you copy too much, or make entire copies of photos in ways that do not satisfy fair use. But the librarians have no idea what you are doing. Is the library nonetheless liable since their machines are used to make the copies? It's kind of the same as Netcom. Its machines are similarly used, but it typically has no knowledge of what is being stored or sent over its servers. So, should the library or Netcom be liable for the misuse by the customer? And now you see how we have moved into the realm of considering when the library should be legally responsible for the infringements by others, which gets into all the fairness issues we just raised. And so the approach with copy machines is to hold the provider, such as the library, liable if it knows that the customer is infringing and participates by continuing to allow her to unlawfully duplicate the materials. Formally, the court calls this contributory infringement and defines it as resulting when the defendant, with knowledge of the infringing activity, induces, causes, or materially contributes to the infringing conduct of another. The inducing component would be like encouraging the gun purchaser to shoot elephant seals. Netcom didn't do anything like that. The more relevant part is knowledge coupled with a material contribution. And here, the court determined that would arise if Netcom were aware of the infringement, had the means to stop it, but chose not to do it. So, think back to the gun example. Usually, when a seller distributes a gun, it loses the power to control its use, even if it learns that it is being used unlawfully. Thus, we do not hold the seller responsible. However, we also concluded that if the seller could exercise control after the transaction, then it might bear responsibility if it knew about the illegality and let it happen anyway. Well, an internet service provider does have the technical ability to remove items from its servers. So, the court said it is fair to hold it responsible as a contributory infringer if it leaves the material up after it learns of the unlawful post. This raises the question, when does an ISP know that a post infringes copyrights? What kind of evidence does it need to be sure that the material is infringing? Is it enough if a person simply calls up the ISP and alleges that a posted document violates their copyrights? Well, anyone could do that, even if they don't own a copyright in the work. They might just want to stop communications by the individual who put up the material. So, should they have to show a copyright registration for the work? Well, that wouldn't really make sense since you don't need a registration to enjoy copyright protection. What if there is a copyright notice on the work? The court says that probably is enough to demonstrate that the person complaining owns a copyright in the work. And in this case, the ISP should take it down or face liability. But what if the posted material is not exactly the same, or there is a plausible fair use argument for posting the work? I mean, what if Lynn Goldsmith went to Netcom and said, "Hey, Andy Warhol put up a picture that infringes the copyright in my Prince photograph." She even shows them her original and a copyright registration. Should Netcom take it down? Because, as it turned out, Warhol's piece did not infringe, so Netcom would be wrong to remove it. Same thing might arise if Rentmeester complained about Nike's photo of Michael Jordan. So, the question of when does the ISP actually know about the infringement can be a real dilemma. And think how you'd feel if an ISP mistakenly took down your stuff when it was totally legitimate. You'd probably be really upset and might even bring suit against the ISP for violating its promise to allow you to freely communicate as long as you don't violate the law or its policies, which you have not. All of a sudden, ISPs may be damned if they take a post down and it turns out it doesn't infringe the copyright, and damned if they leave it up and it turns out it does infringe. So Netcom was in one sense a win for ISPs because they aren't directly liable, and so only face potential concerns after being informed about a specific post. But it did raise all of these other questions about the substantiation needed with the notice. Fortunately, Congress came to the rescue and passed legislation that attempts to balance the interests of the ISP, its customer, and the copyright holder. This remedy comes from the Digital Millennium Copyright Act through what are called notice and takedown procedures, which we will further address in class. To wrap up this chapter, I need to mention one other theory of liability that the judge in Netcom addressed, and that is vicarious liability. The major distinction between contributory and vicarious liability is that with vicarious, the operator is actually profiting from the infringements. That is, it makes money from the infringements. And the more the customers infringe, the more money it makes. So, beyond having control, this ISP, or whoever the operator is, has a financial stake in the infringements. Indeed, you might even say that establishing an environment conducive to infringements is all part of the business plan. In my mind, This makes the operator even worse than a contributory infringer, and I would understand that such an actor might have greater obligations under the law. And so it does. As discussed in Netcom, when the operator has a financial interest in the infringements, then it has a duty to police its system, look for infringements, and use its control to remove them. Thus, the ISP would not have the luxury to wait for someone to inform it about possible infringement. Rather, it has an obligation to look for the infringements, and if it doesn't take reasonable steps to police its platform, it will be liable even if it does not find or otherwise learn about the misconduct. Well, vicarious infringement did not apply to Netcom in this case. Subscribers paid an initial fee, and the ISP did not somehow make more money because the Scientology documents were on the system. However, we will see that in other situations, such as with a litigation against Napster, vicarious liability did indeed become relevant. Okay, you now have a pretty good foundation about the legal responsibility for the actions of others, and how it applies to internet-based businesses. I'll answer any questions you might have about this in class, and we'll take a closer look at those notice and takedown procedures. We will also next consider some more recent applications of these principles, including the debates surrounding file-sharing networks, such as Napster and Grokster.